Thank you very much. Dear esteemed colleagues, ladies and gentlemen, in the next 20 minutes or 15 minutes, I would like to give a comparative legal summary about one of the most fundamental and therefore one of the most essential legal institutions of civil law, legal capacity. Within the framework of the topic, I will outline the legal declarations of child according to the private law rules of the Central European Academy. In first few minutes, I will talk about the definitive approach of child in the Central European countries from the viewpoint of legal regulations and legal theory. After this introductory topic, I will demonstrate the legal capacity and the capacity to act of the child in the civil law of the given countries. Within this framework, I will also summarize the rules and requirements of the emancipation effect of minors' marriage. One of the specificities of jurisprudence is the pursuit to create some kind of legal definition to many elements of the legal system. However, it is not a simple task, and in some cases it may even be questioned whether it is possible to formulate a legal definition of a given element of the legal relationship. This is not an exaggeration, since it is almost impossible to formulate an objective definition that is true and correct in all respects. Therefore, definitions and concepts are often abstract. On the one hand, definitions shall be flexible enough and cannot be too narrow and exclusionary. Moreover, on the other hand, concepts shall be precise and identifiable. With regard to the concept of the child, two jurisprudential approaches can be distinguished. In one method, we can find a sort of legal definition which is then used by case law. In the other method, there is no specific definition in the text of the acts. Czech, Slovak, Serbian, Hungarian, and Romanian systems do not contain a concrete legal definition for the approach of a child, as the legal terminology and the definition of the United Nations Convention on the Rights of a Child can be applied. Moreover, many countries approximate the question from the point of view of sociology and from the concept of family. They emphasize that child is the cornerstone of family. For example, in Romania, we can find rather a sociological point of view than of a legal about the concept of family and children. The relevant act declares that family consists of parents and their children. From the viewpoint of legal capacity, most of the Central European countries interpret the basic rules similar. However, there are differences in its content. For instance, in some countries, the legal capacity comprehends the rules of the so-called act of capacity, or with other words, business capacity, transaction capacity, or legal competency. In addition, in other countries, as for example in Hungary, there are two groups of rights. On the one hand, the abstract basic legal capacity, which means everyone, humans and legal persons as well, shall be entitled to have rights and obligations. On the other hand, the concrete act of capacity, which have separate levels, and in other countries it is called legal capacity. Consequently, we can see that there are differences in the content of legal capacity and age classification of it, and also in the relevant legal declarations could be made by the minor. It is noteworthy that the regulation is similar in Croatia as well, as legal capacity means that any natural person and legal entity may be a holder of rights and obligations. Likewise, in Hungary, within the Croatian scientific and professional legal literature, there is a clear division between the term legal capacity and contractual capacity of persons. Within the Croatian legal order, legal capacity represents the ability of a person to hold rights and duties, while contractual capacity includes the ability to exercise those rights and duties by entering into legal transactions and undertaking actions with a valid legal effect. So firstly, the general rule of legal capacity is an abstract one. Legal capacity is vested on every human being from the moment of birth until death. As birth comes a legal presumption that the child was born alive in most of the countries. The legal consequence and general rule of live birth is the legal capacity, and the baby is treated as a subject of the law as he or she acquires property rights and obligations as a consequence of events that also occurred during his or her fetal life. The Czech Civil Code provides in a general legal capacity as a passive legal capacity. It means that the person has rights and duties. The beginning of passive legal capacity is live birth and lasts until death. In Croatia, every human has full capacity to have rights and obligations, which is an inalienable characteristic of every person. The legal capacity to have rights and duties arises at the birth in Slovakia, which capacity is established if the child is born alive, which is an abstract kind of passive status. The general rule of legal capacity follows that the so-called nasciturus will be the subject of rights and obligations provided that it is born alive. It is also highlights the general rule in every Central European country that nasciturus will not become a full subject of property rights and obligations until is born alive. The Polish civil law emphasizes that the conceived child can acquire rights, but cannot be a person of obligation. The similar rule is applied in Slovenia also, which is called nasciturus fiction. According to the rules of the Czech Civil Code, nasciturus has a passive legal capacity as per the law. Conceived child shall be considered as it was already born if it suits the child's interests. It also shows that Czech civil law presumes the child is born alive. However, if the child is not born alive, he or she is considered as never have been existed. Within the Hungarian framework, a pending legal status of the nasciturus is applied. As per the Civil Code, each person, if born alive, shall have legal capacity from the day of conception. We can find a similar approach according to the Romanian Civil Code, as the capacity to have rights and obligations begins at birth, and however rights of the child are recognized from conception, but only if the child is born alive. From the viewpoint of the rights of nasciturus in Croatia, he or she has especially inheritance rights, as a child already conceived at the moment of the opening of the inheritance shall be regarded as already alive. Consequently, the unborn child will be represented by one of the parents in an inheritance proceeding. It can also be added that an unborn child has no legal capacity, although some rights of personality are protected fully or partially, such as dignity and the right to life after a certain pregnancy stage. In Poland, the notion of legal capacity covers three categories: full legal capacity, limited legal capacity, and lack of legal capacity. Legal capacity is affected by age. Full legal capacity is acquired upon reaching the age of majority. According to the Polish law, children who are under 13 years of age are completely incapacitated. However, a person who has reached the age of 13 may be completely incapacitated if, as a result of mental illness or in particular drunkenness or drug addiction, and the person is unable to direct his or her own conduct. In the Hungarian system, persons who have not yet reached the age of 18 years shall be deemed minors, with the exception of married minors. Minors under 14 years of age are completely incapacitated. A minor shall be of limited capacity if he or she has reached the age of 14 years and younger than 18 years of age. In Czechia, On the one hand, there is a passive legal capacity, and on the other hand, there is an active legal capacity, which covers the capacity to acquire rights by one's legal acts and commit oneself to duties. Within this framework, full legal capacity is acquired upon reaching the age of majority, in general at 15 years. In Slovakia, upon reaching the age of majority, individuals acquire full legal capacity. At the same time, minors possess restricted legal capacity and are only authorized to engage in undertake such legal acts that are adequate to their intellectual and mental competence corresponding to their age. Under Serbian law, full legal transaction capacity is acquired upon reaching the age of majority after turning 18 years old. Serbian family law distinguishes minors under the age of 14 and those between 14 and 18 years of age, senior minors. Senior minors that are 16 years of age and capable of reasoning do not have full legal transaction capacity. However, they have a so-called qualified legal capacity. This qualified legal capacity ensures to file an action before the court in order to receive the court's permission to conclude marriage before reaching the age of majority. The Croatian legal order recognizes 3 levels of legal capacity to act of the child. Limited legal capacity means that a child can by himself, herself enter into certain legal transaction and undertake certain actions with a valid legal effect, but only in situations prescribed by law. The age classification in this sense depends on the legal transactions which is performed by the minor. For example, when reaching the age of 15, the minor who earns money by work can independently dispose of the income provided that it will not endanger the maintenance. Or, for example, a 16-year-old child can independently give consent for a preventive, diagnostic, or therapeutic medical procedure if it doesn't risk the physical or mental health of the patient. In most of the countries, marriage can be concluded before reaching the legal age. In most of the countries, this age threshold is 16 years of age. Legal capacity can be acquired 16 years of age if the child enters into a marriage in Croatia, Hungary, Serbia, Poland, Slovakia, Czechia, and Romania. At the same time, in Slovenia, a marriage can be concluded by a child older than 15 years. It is also worth mentioning that, for example, in Serbia, if a minor after 16 years of age becomes a parent, also shall be regarded as an adult. Summary. From the above mentioned, it can be seen that the rules are fundamentally consistent and regulated along the same logic in countries. However, this doesn't mean that there are no differences at all, which can basically be traced back to the cultural and historical traditions of the given countries. These can be found especially in the conceptual approaches and the definition of age groups, and in the related definition of the scope of legal declarations that can be made independently. However, it is fundamentally clear from the rules that each legal system considers the interests and rights of the children to be of primary importance and the fundamental value. Thank you very much for your kind attention.